Welcome to Bill the Lender podcast, devoted to educating you on a variety of financial subjects with an emphasis on real estate and real estate finance. Please click the button to subscribe to my channel so you don't miss an episode. Then like and share your favorite episodes. Welcome everybody to Bill the Lender podcast. I'm your host, Bill the Lender, and today we have Dan Kapsak. Mr. Kapsak is a principal of Kapsak Estes LLC. His practice is devoted to all aspects of estate and business planning with a special emphasis on elder law. He's a member of the Boulder County Bar Association, the Colorado Bar Association, and is admitted to practice both in state and federal courts in Colorado. Mr. Kapsak is a member of the Elder Law, Tax, Probate, and Trust section of the Colorado and Boulder Bar Association, and is a member of the National Academy of Elder Law Attorneys, NAELA. In the community, he currently is on the board of directors of the Hover community. Dan is a longtime member of Rotary, served as his club's president, and was an assistant governor for District 5450. In his spare time, Dan enjoys road cycling, playing guitar, and relearning double bass. That's the first time I've heard it called that. Is that the stand-up bass?
That's the stand-up bass.
That's awesome. Traveling with his wife, Cheryl, and seeing the world through the eyes of his two grandchildren. Dan, welcome to the show.
Thank you, Bill. Thank you. Glad
How are you today?
I can't complain, and if I do, who cares?
Yeah.
You know?
Well, Dan, we had a great conversation, and one of the things that really struck me and why I wanted to bring you on the show is you have a way of explaining things about what you do and how you do it that makes it easy for people to understand. And I feel like estate planning is one of those subjects that people really shy away from because I think it's intimidating to talk about death or what would happen if we're incapacitated. And people don't really understand what it entails. What is estate planning and why should people think about doing it?
Okay. Well, estate planning is basically when we take what we have and decide who's going to get it when we die or how it's going to be used while we're alive. Everybody has done estate planning in some form or fashion, even if they don't acknowledge it. Because, so for example, Bill, do you have a house?
I do.
Do you own it yourself?
I do.
Your wife is not on it?
No.
Okay. All right. So you've done estate planning.
Right.
Do you have a joint checking account?
I do not. Nope.
Okay. But you've done estate planning.
Yeah.
So, and with married couples, a lot of times they'll have joint ownership of the house, joint ownership of different assets. They've done estate planning. Because to the extent they own something as a joint tenant with someone else, whoever lives longer wins. So even if I own the house with my wife, Cheryl. If my will says it goes to my 3 kids, I die, they're out of luck because by operation of law, whoever is the surviving joint tenant continues to own the property. And girls and kids, I'm sorry, you're out of luck.
Interesting.
People put beneficiary designations on accounts, on IRAs, on 401s, on life insurance. Again, they've done estate planning. The problem is when they do this kind of work, they're not taking into consideration the full overall picture of what their estate is, what they want to accomplish with it. So a lot of times I'll have parents who will put one child on as a beneficiary, presuming when they die, that child is going to share with the siblings. That's usually the response.
Yeah.
There's no obligation because the presumption is mom and dad knew what they were doing and they wanted that fund, that asset to go to that one child.
So estate planning, in your opinion, is the sort of intentional planning of assets. Is it all just assets, or is it what else? Wishes,
Wishes,
intentions,
hopes, intentions, concerns. So I'll pick on my kids because they're not here to kick me. So if Cheryl and I want to give assets to our 3 kids, so we have worries about our oldest, Gabrielle. We may not want to have everything going to her outright. If I'm concerned that she's not going to be managing it correctly, I may want to put it into a trust so that when we die, whatever we have for her goes into this trust, and it's nothing more than a cup. We set it up, the trust is a cup, we have a handle for the trustee. We put the stuff in it, and we say, okay, Gabrielle, you're able to use it however you want, or maybe not however you want. You know, we may say this is not going to take care of her squeeze of the week to take around the world. It may say that she is not able to use those funds to pay off her creditors when she goes up to Blackhawk and gambles up a storm.
So designating your wishes beyond the grave in that case.
Mm-hmm.
But something that people don't often think about is also incapacitation.
Yes. And that's the second half. That's the other half of estate planning, because we want to know who gets what, when, and how. But in the event you walk down the steps of your house, you trip and fall. You're alive, but when you hit the bottom, the synapses are not snapping the way they should. Who steps into your shoes?
Mm-hmm.
Who have you designated or identified to be able to step into your shoes and take care of personal financial matters, take care of healthcare matters? And a lot of times the presumption is, well, I'm married, so my spouse has the right to do that. No. Just because you're married doesn't mean they have control over you or you have control over them. We took care of that with women a long time ago, that they're now almost equal. But those are the kinds of things that we worry about. So who would you trust in the event you couldn't make your own decisions?
When it's a big assumption too that that we're going along just fine, but you could step off the curb and snap your ankle or get hit by a bus.
Right.
Either one.
Right.
And that's probably more real than suddenly it ends, right?
Yeah. Oh, yeah. I mean, I've had a heart attack. I've had a stroke. So it was very important that my wife had power of attorney so that she would have the authority to make decisions for me in the event I was unable to do that. And especially for the first few days after my stroke, that was very important.
Absolutely. Now, in real estate, people in my side of the business, you talked about joint tenants and unintentionally planning. Let's talk about joint tenancy, because that's something that we see very often. What are other ways to take title, and does it make sense to do joint tenants all the time?
Okay. Well, in Colorado today, the default is not joint tenancy, believe it or not. It is tenants in common. As a default in Colorado, when you buy property with more than one person, the default is tenants in common, not joint tenancy. The difference is this: if we own assets as joint tenants, as I'd mentioned earlier, whoever lives longer wins. And that ownership is not going to be controlled by the death of the first to die. It's just whoever lives longest wins.
Right.
With tenants in common, on the other hand, each person owns an identifiable share. So that I die, if I own that property with Cheryl as a tenant in common, my interest will be controlled by my will or my trust, so that I could get Cheryl back for all the grief the grief that I've given her for 40-something years, and pass it to the kids, or to the in-law, or to their spouses. Actually, that would really, get her. But those are the kinds of things that we look at. And so, when you're dealing with loans, when you're dealing with real estate, it's going to be very important How do you own it? Because if it's a blended family, all right, so it's my kids, your kids, our kids together. If we own it as joint tenants, then when you die, I know that my kids are going to get it and your rotten children are just out of the picture.
Mm.
So if we're dealing with a blended family, we want to make sure that the property is at minimum owned as tenants in common, so that when each spouse dies, that interest can ultimately pass to their children. And then there's always the question, all right, what do we do while, so you die, I've got my half, your kids have your half, now I have to deal with your kids owning that property with me. So there are a lot of things that we'll do then to put it into a trust, or arrange language that says when one spouse dies, the surviving spouse has the right to stay in the house as long as they need to or want to. And here are provisions that say when the surviving spouse leaves or dies, here's what happens to that property.
It's good advice. Now, we have a lot of investors that watch this podcast, a lot of real estate professionals as well, and you do business law as well.
Yeah.
So when we have investors and multiple owners going in on a property, what would you recommend in that scenario?
In that scenario, I would recommend they own it in some form of entity, because that would then provide each of them with better assurances. Here's who owns it, here's who's managing it, here's who's responsible for what expenses, for whatever. And we also build in a provision that says, if you and I own this piece of property, and Megan as well, if I want to leave that arrangement, I can't just give my interest to Fiona, my office manager, without
Consulting.
both of you saying yay, yeah, and agreeing. And this way, we don't have to worry about in-laws, outlaws, or whatever else. So as the people are able to decide who gets what, it's memorialized. So there is no question.
Got it. What are some of the other scenarios and other titling ways that you've seen people take title that would be significant?
Okay, in Colorado, basically, we're either just one person. If it's more than one person, it would be as tenants in common or joint tenants. We don't have tenants by the entirety. We don't have community property here in Colorado. So for land ownership, we're basically, for individuals, one person, sole, joint tenant, tenant in common.
Got it. Now, we're seeing more and more people using beneficiary deeds to pass their homes at their deaths and avoid probate. What are your thoughts on beneficiary deeds? And is probate as horrible in Colorado as it's made out to be?
No, I'll deal with probate first, and then we'll talk about beneficiary deeds. Probate, it's a 7-letter word, and basically probate is what we do. We take a will and we say, it's real, follow it. That's probate in its essence. And we have what is called the Uniform Probate Code that applies in every state. Each state, though, however, has taken that code and massaged it into its own idiosyncratic approach to death and dying and the passing of assets. Broad spectrum. On one end of the spectrum, you would have a state like Colorado or Florida. New York is horrendous. Other states where it's very judicial, very formal, where every time you want to do something as a personal representative, you have to get the blessing of the court. Or even if you think you want to do something.
Interesting.
On the other end of the spectrum is a state like Colorado, informal, administrative. I've died. I've nominated you as personal representative. You send my will to the probate registrar of Boulder County. Krista says, oh, I'm sorry Dan died. all right, here are your letters testamentary. Let me know when you're done. So there's no hearing, no going before the court, no asking for blessings here and there or whatever. You just do what needs to be done. When you're done, you yell at Krista, hey, we're done. She says, fine, get out of here.
Wow. That's a big difference.
It is. And, people say, oh, assets are tied up. They're frozen, whatever. If you own an asset in your own name, until the personal representative is approved, that asset is not, you can't play with the asset. But typically it's maybe a week, 2 weeks for the turnaround between putting the paperwork to the probate registrar and Krista coming back with the letters. So probate in Colorado is nothing to fear. And so we'll get a lot of people say, I need a trust. Why? I want to avoid probate. Why?
Well, and that's maybe another reason to invest in Colorado. Most people haven't really thought about that.
Yeah.
And there's a lot of talk about Colorado's overpriced, but when you look at the laws, it's a great place. Not only is it a great place to live.
Oh, yeah. And, the cost of administration, you can do it all by yourself. If you want to do the estate administration or probate of an estate by yourself, you can do it. You can get the forms from the Colorado Supremes. You pick and choose the form you need, get it in, and you're rocking and rolling. We do a lot of it because we want to be taking that burden off the family's shoulders. I like to say we will be radar to your Colonel Potter. So if you can harken back to
that's going to date some folks here.
But that's true. We do the work. We get everything done. Here, sign here, Bill. Here, Bill, here's what you need to look at. Here, Bill, the notice to creditors is going in the paper. Here, Bill, here's what you need to prepare for the inventory. Here, Bill, sign off. We're ready to get everything distributed. Here, Bill, final affidavit. Here, Bill, goodbye, Bill. And all you do is...
And then it's just send me the bill, I guess, at that point.
Well, yeah, but, average estate administration is probably going to be $1,500. That's all.
Oh, that's not bad, though.
No.
Yeah, that's reasonable.
I think so. And we do that on an hourly basis because you never know what we're going to expect. I mean, there can be something coming out of left field that's going to take more time. So a lot of times, all right, attorneys will bill estate administration essentially 2 ways, with a third as a possible option. Some attorneys will do it in terms of a percentage. Here's the value of the estate. We're gonna charge you X% of the value of your estate. Now, that could be $1 million estate, but if it's only a house and your investments, they do that in their sleep, and there's nothing to do.
Mm-hmm. But they're still billing a percentage.
Yeah, or a flat fee.
Right.
And that, again, does not take into consideration what we need to worry about or how difficult or how easy it's going to be. It's just going to be a flat fee. Now, if it's, again, really easy, I made money. But if it's horrible, then I'm taking in the shorts.
Well, so, you would come into problems in and around the beneficiaries? Is that where it gets difficult?
It could be difficult that way. I've got an estate right now where they died. The person died without a will. So, and it's a blended family. One person is inheriting half the estate. The other half of the estate is being inherited by, I think, 27 different cousins. And so now they're arguing. Well, he's got this, and he got the personal property, he got the house, we got the cash, but the cash isn't equal to what he got in terms of the value of the house and the personal possessions, including the Porsche. So now we got fussing. What we do is we do this kind of work on an hourly basis because that's the gold standard for lawyers. So whatever time it takes, we bill. And it's pretty simple that way.
So how can people going back to the beneficiary question, how
Oh,
can
yeah.
how can people make that less complicated, and how should they be approaching beneficiaries?
Okay. Couple concerns. So the beneficiary deed basically says, okay, when I die, I've named a beneficiary. By death, when I die, death certificate is filed with the clerk and recorder's office. Whoever is my beneficiary gets. But again, we run into a lot of families where they'll say, okay, it's the oldest son who inherits, with the understanding or the presumption that they're going to share it with the rest of the siblings. Doesn't happen.
Doesn't happen. Yeah.
Or one of the beneficiaries is disabled, where we're looking at Medicaid, not Medicare, but Medicaid. So they can't inherit outright. So we have to set up a trust, again, a couple, so that whatever's in there is not going to be considered a countable resource for Medicaid eligibility. You can't accomplish that with a beneficiary deed. You can't accomplish the depth of planning. So if I've named my 3 kids as beneficiaries on the deed, what happens if Gabrielle dies before me and I haven't had a chance to do anything? Does her share go to her 2 children? And since they're still 4 and 2, they can't inherit. There's a whole problem there with the conservatorship and whatever else. So to my way of thinking, it's a heck of a lot easier if we own the property, we own the property. No beneficiary deed. Let the will or the trust be the entity to say, here's who gets, how, why, under what conditions.
That makes a lot of sense too, because you can designate your wishes inside of the trust and the will.
Yeah.
Right. And it really is the vehicle for the intention.
Yes, it is.
That's a beautiful way of approaching it. Because and the sad thing is that people are going across their lives and they're acquiring property, they're being a good steward, they're building wealth, they're saving their money, they've got their 401ks and doing all of these things that we're told to do, and there is no thought of something happening.
Well, no, there is thought, Bill. There is thought.
But that's to your earlier point. Exactly. Whether you make the choice to be intentional about it, you're still making the choice.
You're making the choice, but you're not taking into consideration the overall effect of that decision.
Right.
And that's what we run, that's what we do. We say, okay, how do you want to accomplish what do you want to accomplish? Now, here's how we would look at accomplishing those goals. And we look at assets, we look at income, we look at how you've designated beneficiaries. Does it make sense? Does it not make sense? What are options? I spoke to a client yesterday. They have a decent amount in their 401k. They also have a decent amount in their trust outside of that qualified plan. What makes the most sense in terms of taking RMD, required minimum distributions? Should he just be taking that? Should he be taking more? Because with qualified plans, 401 IRA, you don't have the ability to say, if I die and this goes to Cheryl, but she's not able to manage it, we don't have that. We don't have that because it's just beneficiary. Technically, you can name a trust, but then everybody gets it there. Their shorts in a knot because then, oh my God, I have to pay the taxes. Well, it's a deferred plan. It's not tax-free, it's tax-deferred. So when we look at plans like that, the question is, all right, how do you want to deal with it? So if I have a client who wants to leave money for his wife, but she spends it 17 ways before she's ever gotten $1. He wants to make sure that his IRA 401 goes into this trust. Oh yeah, well, George, you're going to have a tax hit. Ooh. It's going to happen one way or the other.
Right.
And I liken it to taking
IRS always gets their money, man.
Well, the infernal revenue, please.
Yes.
Okay. The question is, when you put a Band-Aid on some furry part of your anatomy, and then you have to take it off, do you go hair by hair by hair?
No, you just rip that sucker off.
Or, yeah. And that's what, that's how we look at using IRAs, 401ks in a trust. You're going to be paying the taxes one way or the other. What's more important? Protecting that loved one and making sure that the funds are there for their needs, or just give it to them outright, let them spend it the way the hell they wanted, yes or no, or whatever.
But you're helping folks find that middle ground, and that's what I think is important. So, Dan, this has been a great conversation. I definitely want to bring you back on the show to dig into some more of this, just because it's complicated and something that I don't think people really think about. But a lot of our listenership is out there building, acquiring real estate and assets, and they need to understand how to protect it. So, if people want more information, what's the best way to reach out to you?
They can reach me at on our phone at 303-651-9330. They can go onto our website, kapsakestes.com. They can email us. Smoke signals work as well.
Well, Dan, this has been great. And this has been another episode of Build a Lender podcast. We talk about all things financial service related and how it impacts your real estate and real estate finance. Until next time, guys, we'll see you next week. Thanks for listening to Build the Lender podcast. Please reach out to me with any questions at 303-877-6323.